Is the United States just short of the 250th anniversary of the signing of the Declaration of Independence about to experience a constitutional crisis? And if so, what does that really mean? Welcome, I'm Jim Falk, and in today's program we'll be discussing constitutional law, a body of law that outlines and provides the structure and powers on which our democracy is based. A key characteristic of our government has been the separation of powers, designed to provide checks and balances for each branch of government. Of course, the executive, legislative, and judicial. Over the last few months, the executive branch, led by President Trump, now in his second term, has been pushing to the limit its power to the point where leading constitutional scholars are warning that the United States could be on the edge of a constitutional crisis. To provide context and to explain why all of us should have at least a basic knowledge of constitutional law, we turn to Paul Watler, a frequent guest and my go-to expert on legal issues. Paul is an attorney and partner with Jackson Walker, known for his effective and successful work on First Amendment cases. Paul, wonderful to have you on the program.
Thank you, Jim. Glad to be back.
And what an important topic for us to talk
Absolutely,
about.
very timely.
So, for the benefit of all of us, what is constitutional law?
Well, it's primarily the interpretations that the Supreme Court have made of different constitutional provisions over the 2 centuries plus now since the Constitution was adopted. James Madison and Alexander Hamilton and those guys sat down and wrote the Constitution, and it became effective, adopted by enough states to go into effect in 1789. And ever since then, there have been cases and controversies that arise in different provisions about what does this particular constitutional provision mean, what does this particular Bill of Rights, what's the extent of the liberties that it guarantees, those sort of things. So constitutional law is basically not only the Constitution, but the body of primarily case law that has developed over the years to interpret and fill out the meaning of the Constitution.
And it's probably not stressed enough. I was a major in political science, and I did not take a course in constitutional law. I guess all attorneys have to.
Of course, yes. Yeah, it's usually part of the first year curriculum in most law schools.
And why should we care about it?
Well, it's our foundational document. Again, it sets up the 3 branches of government, as you were mentioning. Yeah. It enumerates certain rights or certain responsibilities, certain duties, certain powers in each branch. There are so-called co-equal branches, and we have this separation of powers, which you also mentioned. And the way that works in practice, there's a lot of things that have had to be worked out over the years, over the centuries, actually. And it affects almost so many aspects of our daily lives. And fundamentally, our right, the liberties that we have, the right of free speech, the right of free association, the right to travel across state lines, the right to engage in interstate commerce, the right to be sure that we have a common defense provided for this. All that flows from our Constitution and the interpretation of the Constitution. So every citizen has a stake in how our Constitution works and how the courts decide what our rights and freedoms are under that Constitution.
You know, I always have close to my desk some books by Stephen Breyer, who of course served on the Supreme Court for a number of years. This book, Reading the Constitution, Why I Chose Pragmatism and Not Textualism. In your view, is the Constitution a document that is continuing being evolved?
Well, Breyer talks about that in his recent book, and there's sort of 2 schools of thought. The school of thought that has been ascendant really for the last 30 years or so, particularly by the late Justice Scalia and others on the current court that adhere to it, Justice Alito, Justice Thomas certainly come to mind, basically stand for the proposition that the fundamental way to interpret the Constitution is according to the text of the Constitution, according to the original meaning of the Constitution, both by the authors of the Constitution and by the people who were living under the Constitution at the time it was adopted. What did these words mean to ordinary citizens, not just lawyers, not just members of Congress, not just members of a constitutional convention, but what was the common understanding of that? So that's sort of textualism, and in the constitutional context, that's called originalism, really trying to look at the original meaning and to give effect of that. And Breyer, makes the case, and there's a lot of adherence to this point of view, that, well, the Constitution is more than that. It's not something that was set in stone 225 years ago plus now. It has to be a document that provides for and adapts to the circumstances of the current era. And so Breyer talks about pragmatism, about and I have trouble saying this myself, but finding the actual purpose
Right.
of a constitutional provision,
And bring it up to date.
Right. It's not
Yeah.
to him. It's not just the words on the paper, but what is the purpose? What is the evil that was intended to be addressed, or the liberty to be secured? What was the greater purpose behind the particular words that we're showing, more so than just the strict meaning of those words in black and white?
And one of the things that I've found interesting in this book, too, is how Breyer talks about how the original founders wanted the Constitution to be designed so that it would, in a sense, prevent conflict and to hold the country together.
Of course, that's a big part of the Constitution, but they also knew that they couldn't anticipate every contingency, every circumstance that might arise. They knew that there would be public emergencies from time to time. There would be, turns in the economy, upturns and downturns. There would be different issues. So they wanted to have a structure that could address that. That was well-defined enough that people understood the different roles, but fluid enough that could deal with different circumstances that may arrive over the centuries.
And we'll talk about this more in just a few minutes, but the United States right now perhaps is having pressure on its Constitution like never before, but that's relatively new. Of course, we had the Civil War, but overall, is it fair to say that the Constitution is the glue that has kept our society together?
Oh, absolutely. I mean, it's what binds all 50 states. We've evolved from 13 original colonies that formed the United States and adopted the Constitution until now 50 different states. We're a continental-wide sovereign nation. So what has the building block for that has been the Constitution. It provided for instance, the expansion of states, the admission of new states to the Union. Of course, we fought, a terrible civil war back in the 1860s that really, it's been called that what happened as a result of the Civil War and what succeeded it in the Reconstruction period as the second founding of the Constitution, because up to that time, of course, the central controversy then was slavery, and the southern states viewed it as a question of property and a question of states' rights, and that they had the right under their state laws to engage in slavery, and that Congress couldn't tell them much about it. And so a civil war was fought and ultimately resolved in obviously the emancipation of the slaves, but also adoption of what's called the Civil War era amendments, most notably the 14th Amendment that guaranteed citizenship to all persons in the United States, including former slaves, and defined many of the rights of citizenship. And so it remade the Constitution. It also made the Bill of Rights, which was the first 10 amendments that had been adopted early. It made it had always been operative, the Bill of Rights, against the federal government, but the 14th Amendment explicitly made the Bill of Rights operative against the states as well. So this was a very fundamental new development in the post-Civil War era that came online, and we've been working out some of those wrinkles for 150 years since.
Many countries look to the United States and its Constitution as a model on a basis. You certainly saw that after the dissolution of the Soviet Union. Many of those countries followed or looked at the U.S. Constitution, and they've often had amendments. it is awfully difficult to pass an amendment in the United States.
It is.
Is that a weakness or a strength?
Well, it depends on, I guess, your fundamental view of how wise and sound the Constitution is. And a lot of people believe that it has stood the test of time. And the difficulty in amending it, in some people's view, is a virtue because it's not being cast asunder in the amendment process. It's hopefully being refined and better developed. So I think my own view would be that it's probably a good thing. Because we did have wise people, wise men, as it was exclusively in that era, but they did design a document that has endured these centuries and for a reason. And so we should be cautious about amending it willy-nilly.
The document endures, but the Supreme Court sometimes changes, reverses, interprets certain issues differently. And I want to take advantage of you being here and ask you, what are, say, the 2 or 3 most important cases?
Well, that's always an interesting question, and different lawyers,
I'm sure people
and different judges, different scholars.
But you're in the studio right now.
There you go. But so there are several that come to mind for me. And they're very pertinent and relevant to issues that are going on today, I would say, for at least several of these. First, I would start with Marbury versus Madison, which was a 1804 decision during the administration of Thomas Jefferson, our third president. And it basically stands for a very foundational principle of constitutional law, in that it was written by Chief Justice Marshall, who was probably the most hallowed of the early Chief Justices. And that decision established the principle, and Marshall wrote this in his opinion, that it is fundamentally the province of the judiciary, of the courts, in particular the Supreme Court, to say what the law is. Congress enacts the law, and the executive branch, the president, is charged with enforcing the law. But it's at the end of the day, it's up to the Supreme Court to say what the law is. In other words, if a particular piece of legislation or perhaps an executive action is constitutional or not. And so Marbury versus Madison staked out that territory, which has been respected and has been the norm ever since, that the Supreme Court does get the final word on whether something is constitutional or not, whether it is really consistent with the form of government that our founders adopted through the Constitution. So that's one, and that goes back almost to the early days of the adoption of the Constitution, within a couple decades at least. But I would also point to a very famous case in the 20th century, mid-20th century, of course, would be Brown versus Board of Education, which there had been
1954,
and that struck down the whole system of segregation, the framework for segregation that had existed primarily in the southern states, in this whole concept of separate but equal. And that is something that had evolved in the late 19th century. In the 1890s, the Supreme Court had issued an opinion called Plessy versus Ferguson, and that involved, I believe it was in the city of New Orleans, where there were segregated streetcars provided for. And a black citizen complained that he was being denied his right to ride in whatever car that he wanted to, and he objected to the segregation. But the court in Plessy versus Ferguson said, as long as there are equal facilities
that's
provided,
separation but equal.
Separate but equal.
Yeah.
If the facilities that are provided for the race that is segregated away from the whites is equal, then the Constitution that passes constitutional muster. And that was the law for 65 years or thereafter, until Brown versus Board of Education. Of course, by then there's not only a great spread of this framework, where there was separate high schools, separate school systems, separate bus systems, separate almost everything to separate the races. And in the educational context, the complaint was made that these schools are inferior, that they are not, in fact, not equal. And the Supreme Court adopted that point of view and famously said that separate is inherently unequal, and that it is unconstitutional. So that led to the desegregation of our schools, and it was one of the major developments that's really sparked the civil rights revolution of the 50s and 60s that ensued from there. So I would put that up in the in my top three for sure. And then a little bit closer to home for me and the law practice that I've had for a number of years, in which I've represented news organizations, journalists, defend them in First Amendment and libel cases, for instance. But a really foundational decision in that area is the New York Times versus Sullivan case, which is a civil rights
That
era
was what,
case.
about 2 or 3 years ago?
No, that was 1964.
Oh, that, okay.
That was back in the civil rights era.
All right.
And it has an interesting background. It relates to Martin Luther King, and Martin Luther King having been jailed in Birmingham, and an advocacy group in his behalf bought an ad in the New York Times, and the headline of the ad was "Heed Their Rising Voices," and it was amplifying Martin Luther King and his followers, their complaints about segregation and about being denied voting rights and those sort of things. And it made a number of statements about Martin Luther King and about him having been arrested. Some of those statements were actually factually incorrect. I mean, it was fundamentally advocating the extension of voting rights to African Americans, total equality of treatment under the law to African Americans, but some of the facts that they cited were wrong. And so, in particular, the police commissioner of Birmingham, Alabama, a guy named Sullivan, took offense, and he claimed that it had defamed his character because it made it appear that he had jailed Martin Luther King without any kind of lawful cause, and he said he had plenty of cause to jail him. So this case, he sued the New York Times that had published this advertisement, and the case went to trial, and there was a jury verdict that was returned with a judgment of $500,000 in damages, which in
a lot of money.
Early 1960s was quite a bit of money and an actual financial threat to the viability of the New York Times. So that case got appealed all the way to the U.S. Supreme Court, and the court said, well, when a public official, such as the police commissioner of Birmingham, Alabama, or other public officials bring a case claiming that their reputation has been defamed, they have a higher burden of proof to establish that. They have to prove that the news organization, the New York Times in that case, actually had a state of mind that was described as actual malice. And that's kind of a peculiar phrase because it doesn't so much mean malice per se, but it means an attitude towards the truth, that the publisher of this statement about a public official knew or had doubts as to the truth, knew it was false or had doubts as to the truth. So it's basically a higher burden of proof. The effect of it is interesting because if you think after 1964, more or less, we had the press became more emboldened, some people would say, more aggressive, more investigative reporting. They had less fear of being curbed by ruinous defamation cases. And so particularly in the decades up until the advent of social media, a lot of the what we call legacy media or mainstream media really flourished in those days and really rose up. We think about the reporting that was done about the Vietnam War that in the immediate aftermath of Times versus Sullivan, a lot of it directed towards President Johnson and his administration, and then President Nixon and Watergate and all that. We saw a kind of a flowering or a resurgence of the news media, and I personally tend to attribute that to.
So right now it's a bit different, though, isn't it?
It's a bit different, and it's different now. I think more so because Times versus Sullivan is still good law, still on the books. It's under challenge, but I think what has changed since the 60s and 70s and the heydays of the Vietnam reporting and the Watergate reporting is not so much the law, because the law is still there, but it's the technological structure of the media. Now we have the rise of social media. Right. We have,
and it happens so quickly.
Rather than the press serving as a gatekeeper, anyone who has a Twitter account or an X account.
Everybody's a journalist.
Everyone's a journalist. Everyone's a publisher. Everyone can spread the word as they see fit.
I want to be sure we have time to talk a little bit about what I said in the open, and that is whether or not the United States is on the verge of a constitutional crisis and what that means. You and I both know Michael Luddick, who got very close to being on the Supreme Court.
Yes.
He recently, was a federal judge. He recently wrote a New York Times opinion piece where he said President Trump has provoked a constitutional crisis with his stunning frontal assault on the third branch of government in the American system of justice. Is that too strong of a statement from Judge Luddick?
Well, it sometimes depends on your point of view. So there's certainly a number of people that subscribe to Judge Luddick's point of view that we are on the precipice of a constitutional crisis.
And what does that mean?
Well, here I think, particularly in this context, is that really for the first, and we can debate exactly how long this was true, but for the first 100, 150 years of our constitutional democracy, Congress was really ascendant. Congress was the body, the branch of government that had the greatest authority, the greatest deference from the other branches. And Congress really set the agenda for the federal government. Mm-hmm. And to some degree, the president was kind of a functionary. And what we've seen, particularly since World War II and since just a completely different world order than existed back in the 18th and 19th centuries, is the president has become more ascendant. The president is more dominant. And now we're kind of at the far end of that, where we have a president who is very much intent on testing how expansive the powers of the presidency really are, and is willing to do so without regard, apparently, for the norms that most presidents, have Democrat or Republican, have operated under, certainly since, again, the World War II era. And so what may restrain a president and what gives rise to the thought that we may be headed to a constitutional crisis is, again, three branches of government, separation of powers that provide checks and balances. The Supreme Court, the judiciary, provides a check and balance on the executive and sometimes on Congress as well. So what Judge Luddick and others are talking about is whether or not, how the courts will react to assertions of power that have not previously been recognized to be held by the president.
And one thing that has surprised me is how much involvement district courts have right now.
Yes.
And that a district court, whether it's in California or New York, can put in place essentially a national
There's great controversy
injunction
over nationwide injunctions.
And you're seeing that on deportations, you're seeing on COVID actions, debt relief. Is this a relatively new phenomenon, and will it be tested?
It's new in the sense that there's been more occasions for issuance of nationwide injunctions over the last 2 decades, approximately. And there was probably the most significant expansion of that occurred during the first Trump administration. There were several dozens of cases, and often they were brought by people that were perceived to be Democrats, Democratic attorney generals, Democratic partisans, or whatever. And there were a number of instances where there were nationwide injunctions issued then. Then under President Biden, who of course succeeded Mr. Trump in his after his first term, yes. So it went the other way. There were, particularly Republican coalitions of Republican state attorney generals who were challenging Biden on immigration, debt relief, student loans, and so forth. And so it depended on whose ox was being gored. If it was a Republican administration and
this isn't good.
Yeah,
I mean, it's becoming overly political.
Yes,
right?
And a lot of it also has to do with the perception of the opportunity to forum shop or to file a case with a particular district where there's an opportunity that you're going to get a particular judge who has been appointed. Obviously, judges are appointed by presidents of one party or the other, and oftentimes, litigants who are democratically oriented look for a Democratic judge to file their lawsuit. Most of our judicial districts across the country are multi-judge judicial districts, but a few of them only have one judge. And those that have one judge often, will...
How does that happen?
Well, for instance, in North Texas where we are, we have the Northern District of Texas that goes all the way from the Dallas-Fort Worth area up to Amarillo, and there's different divisions of that district. And most of those divisions in the larger urban areas, Dallas and Fort Worth, have multiple judges. But some of the smaller urban areas,
so it's set up
Amarillo,
by population, or Marshall, Texas? That's one of the famous
actually,
ones.
Marshall has 2 federal judges, but Amarillo in particular has only 1 federal judge, and currently it's a judge that President Trump appointed in his first term. And so cases tend to get filed in his court.
A little judge shopping.
Yeah, and so that all plays into whether that district judge, say in Amarillo, Texas, should be able to issue a nationwide injunction that would stop President Biden.
And then when that happens, then the next step is Court of Appeals, right?
Court of Appeals, and then ultimately
the
Supreme Court review.
We have just a little bit more time, and I want to hear your thoughts on Trump v. the United States, which was a 2024 case about presidential immunity.
Right. So that was a case that arose out of, if you recall, and I'm sure most of your viewers will, President Trump had been indicted in two cases in particular, one dealing with January 6th and the allegation essentially that he had incited the insurrection and had attempted to interfere with Congress counting the electoral votes. And out of that particular indictment, there was a challenge by President Trump, who was former President Trump at that time, an assertion that he was immune from that prosecution because what he did at the end of his term in 2020 in connection with the January 6th event, shall we say, was part of his presidential powers. And then because he was exercising his presidential powers...
Official acts. Right.
He said they were official acts. And of course, the Jack Smith, the prosecutor, the special counsel, contended that these were not official acts, that he was acting in his private interest rather than exercising official duties of the president. But the result of that was a Supreme Court decision just about almost a year ago saying that the president's exercise of core constitutional duties, such as acting as commander-in-chief and some other roles, the president has provided immunity for exercising his power in that realm. Still remains to be worked out extensively how extensive.
I mean, it was quite ambiguous the way that the opinion was drafted.
It is, and so there's a lot to be worked out, and I think a lot of the things that we're talking about, that Judge Luddick was talking about, potential constitutional crisis, that decision may have a lot to say about how those get worked out.
Paul, many thanks again for being with us, and I really marvel at the way you can take these complicated concepts and make it so that we can all understand it. And for those of you who want to learn more, the National Constitution Center offers free courses and pages of resource materials that I found very helpful in preparing to talk with you today.
Yes, I did.
And to all of you, thanks again for joining our program, where we talk about things that matter with people who care.